Draft Legal Aid, Sentencing and Punishment of Offenders Act 2012, Legal Aid, Domestic Abuse, Miscellaneous Amendments Order 2025.
I call the Minister to move the motion.
Thank you, Chair, and it's a pleasure to serve under your chairship. This draft instrument before us today makes a number of important changes to ensure that legal aid continues to support victims of domestic abuse. The instrument is an important part of the government's commitment to ensure that legal aid continues to be available to those most in need and continues to serve some of the most vulnerable people in our society who need our support. It also ensures that our legal aid legislation is aligned with wider government legislation on domestic abuse and immigration law. Principally, this statutory instrument does four things. Firstly, this draft instrument will make changes to enhance the scope of immigration legal aid. It will make legal aid available for those eligible to apply for settlements in the United Kingdom as a victim of domestic abuse under the immigration rules. This change will ensure that all eligible domestic abuse victims can access legal aid for applications under this immigration route. Secondly, it will amend the evidence requirements for domestic abuse victims applying for legal aid. It will do this by enabling victims to present evidence of abuse from appropriate medical practitioners overseas. Thirdly, this draft instrument will make changes to terminology to align with the Domestic Abuse Act 2021, replacing the terms domestic violence with domestic abuse and financial abuse with economic abuse. This instrument will also recognise that abuse against an individual may consist of behaviour directed at another individual, for example, at the victim's child. These changes will ensure consistency with wider legislation. Fourthly and finally, this statutory instrument will make changes to complement instruments made in 2023 and 2024 in relation to the scope of legal aid, in relation to domestic abuse protection orders and domestic abuse protection notices. If enacted, this instrument will ensure fuller availability of legal aid for individuals in respect of these orders. Before turning to each of those amendments and provisions in detail, I will take a moment to outline how the legal aid scheme works as a matter of generality. In general, civil legal aid is available to an individual if their issue is listed within Part 1 of Schedule 1 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012, otherwise known as LASPO. Then in most cases, an individual must pass a means test, a check on their financial eligibility, and a merits test, a check to ensure the taxpayer is not funding unmeritorious cases. In certain cases, most notably those involving victims of domestic abuse or child abuse, evidence requirements also need to be satisfied. Turning then to each of the four topics covered in this order. Firstly, amendments are made to the availability of immigration legal aid for victims of domestic abuse who are applying for leave to enter or remain in the UK. Currently, legal aid is available for some victims of domestic abuse who are eligible to apply for leave to remain in the UK under the Home Office immigration rules, subject to means and merits tests. The immigration rules set out the rules for entering and remaining in the UK. The immigration rules include an appendix victim of domestic abuse, which I'll henceforth refer to as the appendix. The appendix concerns victims whose leave to remain in the UK was based on their partner or spouse's immigration status and whose relationship has broken down as a result of domestic abuse. It is the route by which victims can apply for settlement in the UK independent of their partner's status, ensuring that they can escape the abusive relationship without having to leave or be removed from the UK as a result. The eligibility requirements in the appendix are amended from time to time, and that's what we're doing here. This instrument amends LASPO to ensure that legal aid provision for victims applying for leave to enter or remain in the UK is aligned to the latest requirements set out in the appendix. The changes will ensure that this alignment will continue in the event amendments are made to the appendix in future. This will mean that all victims of domestic abuse can access legal aid to assist with an application for leave to enter or remain under the appendix, subject to means and merits test.
Testimony.
Thank you, Chair, and thank you very much indeed to the Minister for giving way. I wanted to just clarify what the situation might be. It's a slightly different situation, but to clarify the Home Office's response when one of my constituents who came here with her partner, who was coming into the country seeking leave to remain in the UK, and he was actually the perpetrator of domestic abuse. He was arrested 4 times for domestic abuse, and she alerted the Home Office to the fact that this had happened. applications, literally sending in the film. I wondered if the Minister might actually elucidate a little how it is that one can clock into the Home Office and they don't do as they did and grant that man leave to remain in the UK, and he has now, of course, vanished off the face of the earth. Thank you.
Well, thank you for raising that case. The circumstances that she describes are appalling. Obviously, I can't comment on the specifics of the case, and ultimately it would have been a matter for the Home Office how they dealt with that. But where there is evidence of domestic abuse and where that results in a criminal conviction, that's exactly what the changes that we're making now are designed to protect and extend legal aid to those victims of domestic abuse where the perpetrator immigration status bears on theirs. But she's right that the circumstances you've described almost not quite flip this on its head, but come at the issue from a different angle. But either way, clearly what she's describing is appalling and is something that we shouldn't be rewarding either with a grant of leave to remain in this country. And indeed, where someone is convicted of an offence, we should be looking to take all steps to remove them from this country.
Thank you. Thank you for giving away as well. Thank you, Chair. I would just say I welcome in broad outline what it is that she's describing in the statutory instrument. Of course, I wanted just to highlight that particular case. It's very distressing for the constituent concerned.
Indeed, and she's very welcome to write to me about that specific case if the Ministry of Justice is the appropriate place to deal with it. And of course, I will respond to her. It may well be that it's a question for the relevant Home Office Minister. Secondly, this instrument will make changes to the evidence requirements that victims of domestic abuse must satisfy in order to receive legal aid. Acceptable forms of evidence are set out in Schedule 1 of the Civil Legal Aid Procedure Regulations 2012. Currently, certain forms of overseas evidence are accepted as evidence of domestic abuse. For example, legal aid applications may include supporting documentation concerning an arrest or a police caution abroad. However, currently, evidence from overseas medical practitioners of domestic abuse is not accepted. The government wishes to change regulations to enable evidence from appropriate health professionals who are licensed and registered overseas to be accepted for legal aid applications. This will enhance the ability of victims to take action against perpetrators. Thirdly, the statutory instrument will amend terminology within LASPO and associated regulations to align with the Domestic Abuse Act 2021. Since the introduction of the Domestic Abuse Act, terminology across government has moved away from terms such as domestic violence towards domestic abuse to explicitly recognise that perpetrators can often use more than just physical violence to harm an individual. Within its definition of domestic abuse, the Domestic Abuse Act describes such behaviour as including physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological, emotional or other abuse. The inclusion of the term economic abuse in this definition, rather than financial abuse, which is currently used within LASPO, also reflects a shift in recent years to explicitly acknowledge that abuse often goes beyond interfering with monies and finances to include economic resources more broadly, such as things that money can buy. Examples of this might include housing, possessions, and clothing. Further, the Domestic Abuse Act expressly states that domestic abuse of an individual includes behaviour and conduct directed at another person. For example, an abuser may direct behaviour towards a child in the household in order to facilitate or perpetuate the abuse of their partner. The definition of domestic violence in LASPO recognises that abuse extends beyond physical violence and therefore implicitly includes abuse directed at third parties. But by updating LASPO terminology to align with wording used in the Domestic Abuse Act, we aim to reduce the risk of victims perceiving that the abuse they are experiencing is out of scope for legal aid funding. Fourthly and finally, this instrument complements previous statutory instruments which made provision for bringing legal aid into scope for victims, third parties and those subject to domestic abuse protection orders and domestic abuse protection notices. DAPOs and DAPINs, if I can say it like that way, as they are known, are new orders that are now available within certain areas in Greater Manchester, in 3 London boroughs, Bromley, Croydon and Sutton, Cleveland, and are used by the British Transport Police within these areas. and we are shortly extending DAPOs and DAPNs to North Wales. This instrument makes further changes to LASPO and the Criminal Legal Aid General Regulations 2013 to bring other aspects of the Domestic Abuse Act in relation to DAPOs and DAPNs within scope of civil and criminal legal aid. These changes help ensure fuller availability of legal aid for individuals in respect of these orders. These changes are technical, but they are designed to address unintended gaps in the provision. To conclude, honourable members, the draft instrument before us will make legal aid available to some of society's most vulnerable people, furthering this government's ambition to support victims of domestic abuse.
The question is that the committee has considered the draft Legal Aid Sentencing and Punishment of Offenders Act 2012, brackets, Legal Aid Domestic Abuse, close brackets, brackets, Miscellaneous Amendments, brackets, Order 2025. Mike Wood.
Thank you, Sir Desmond, and it's a pleasure to serve under your chairmanship this evening. Legal aid plays a critical role in our justice system, but particularly for the most vulnerable in society. And access to that legal advice and representation can be a lifeline for individuals facing incredibly difficult circumstances. And for those who have experienced domestic abuse, they are often in particular need of such support. And that's why any changes to the legal aid framework in this area want careful consideration by this committee. It is clear that a significant number of the changes in this draft order help legal aid provisions to keep pace with the evolving legal landscape. The alignment of terminology, moving from domestic violence to domestic abuse, from financial to economic abuse, for example, is a necessary step to reflect the broader understanding of the multifaceted nature of abuse, consistent with the landmark Domestic Abuse Act 2021. But this modernisation of language isn't merely semantic. It can help to make sure that a wider range of behaviours and their impact are properly recognised within the legal aid system, and so they have our support. The amendments relating to immigration legal aid for victims of domestic abuse also warrant careful attention. The inclusion of those applying for leave to remain under the updated appendix to the immigration rules is a change that addresses a specific vulnerability. Individuals whose immigration status is tied to an abusive partner are in a precarious position. So we support these changes, whilst obviously we'll be monitoring how they are implemented closely, because we agree that the changes to the evidential requirement in private law cases in particular, allowing medical evidence from registered overseas health professionals, are a pragmatic step. Survivors of abuse may have sought medical attention outside of the UK, and it is sensible and right that such evidence should be considered in legal aid applications. People who are fleeing abuse should not be inadvertently disadvantaged in access to legal aid. The series of amendments concerning domestic abuse protection notices and orders represent a further stage in the integration of these relatively new protective measures into the legal aid framework. DAPNs and DAPOs were introduced to provide a more streamlined and effective protection for victims of domestic abuse. The previous government laid statutory instruments in 2023 and 2024 to amend legislation in order to provide access to legal aid for both victims and for respondents where appropriate. This instrument makes further amendments to that, so that the appropriate type of legal aid, civil or criminal, is available to those who are party to DAPO proceedings and for those subject to DAPNs. It is right that victims and, where appropriate, respondents in those proceedings should both have access to legal representation to ensure fair and just outcomes. And so we will be particularly interested in the effects of these changes that we support in principle, and we particularly note the government's ongoing evaluation of the DAPN and DAPO pilot, which was launched in those locations that the Minister referred to on 27th of November of last year, and how those legal aid provisions interact with the findings of that review. I understand that no formal consultation was undertaken specifically for this instrument, as the government views these as technical amendments aligning with the existing policy and legislation. And so whilst we understand the rationale provided, we would reiterate the importance of ongoing dialogue with stakeholders, including legal aid providers and those representing victims of domestic abuse, to ensure that the practical implementation of these changes is smooth and effective. The commitment from the Ministry of Justice and the Legal Aid Agency to monitor the impact of these amendments on the legal aid scheme is important to ensure the transparency and adequate functioning of the legal aid system. The impact assessment accompanying this instrument provided a degree of insight into the anticipated costs and effect of these changes, and we note the estimated increase in the legal aid fund related to the expansion of immigration legal aid, and the assessment that other amendments are unlikely to result in a substantial increase in applications. We will monitor that closely and call on the government to similarly keep these assessments under regular review as those changes take effect. In conclusion, Sir Desmond, while we acknowledge the government's stated aims and the technical nature of many of these amendments, we also recognise the profound impact that legal aid has on the lives of vulnerable individuals. Ensuring that the system is accessible to those who genuinely need it, is up to date, and reflects the realities faced by victims of domestic abuse is a shared objective. And so on the basis of the information provided and the commitment to ongoing monitoring and review, we will not be dividing on this order today.
Minister.
Thank you, Chair, and I'd like to thank the honourable members for everyone's contribution to a debate on a really important topic, and I think that the consensus that has been expressed today is truly welcome, given the people that we are talking about who will be impacted by what are perhaps technical changes, but as the member for Kings Swinford and South Staffordshire so rightly pointed out, affect some of the most vulnerable people in need who need to navigate a complex legal and justice system, and accessing legal aid and the accessibility of that system is so critical to their ability to both know their rights and enforce those rights. So I truly welcome his support, both for the changes that, as he rightly says, are not just semantic but are meaningful and will, we hope, capture a wider types of behaviour within the scope of legal aid, but also supporting the accessibility of legal aid in the context of both the immigration system and in relation to DAPOs and DAPINs. I also want to thank the member for Wells and Mendip Hills for her intervention, and as I said, that may be a case that we can follow up on. Finally, let me say that in relation to DAPO specifically, that the Ministry of Justice is piloting these orders because we believe that they can work, and with the aspiration of rolling them out, but obviously we'll do that in an evidence-based way. The early signs I can report to the committee are good, and both police and courts are finding that the orders are working, that they are resulting in actual perpetrators being put behind bars for breaching those DAPOs, and requiring those perpetrators to attend behaviour change programmes in order to alter their behaviour towards partners and others impacted by what are ultimately heinous types of coercion. So the early signs are good, but we will be guided by the evidence and will, of course, keep the House updated on how that is bearing out. But I welcome members' support for what are technical but truly important changes.
The question is that the committee has considered the draft Legal Aid Sentencing and Punishment of Offenders Act 2012, Legal Aid Domestic Abuse Miscellaneous Amendments Order 2025. As many are of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Order. Order.